Hello, everybody. Welcome, welcome, welcome. Um, Today, we're talking about one of my most favorite visas, which is a family based visa to bring your parents to the US. So, this is um, this webinar is only focused on bringing your parents. So, if you are interested in bringing your spouse, your child, we'll hold other webinars or master classes on those. Okay, so if you don't know who I am, my name is Priya Alagiri. I am the founder of the Alagiri Immigration Law Firm. We are niche, we are boutique, we only handle particular types of visas, which makes us very knowledgeable in those particular types of visas. I myself have, over 15 years of experience in immigration law, and we've handled thousands of cases, and we have tons of approvals. Here are a few of our clients who were kind enough to give us some testimonials. And our clients are from all over the country. Okay, so let's get into the substance. But before I do that, I have to give you a quick disclaimer. Anything I say in this webinar does not create an attorney-client relationship. We cannot guarantee any outcomes. And this is for informational purposes. Okay, so all the legal stuff is out of the way. So let's talk about the substance of this particular family-based visa. Okay, just to give you a broad overview, right? There are two types of family-based immigrant visas, like shorthand, like green card visas. And the two types are first the immediate relative visa, and then the second type is the family preference visa. So this is really important for you to know which type of visa you're applying for your parent or family member. Okay, so here's the difference. Preference visas are subject to numerical limits, right? So maybe there's only a certain number of visas that are given for each preference category. So you've probably heard of, the various categories: F1, F2, F3, F4. That means F means family. So those are categories. F2 is the second category. F1, the first category. So those are subject to limits, right? So if you want to bring your sibling over, you're under F4, and you have to wait for a visa to become available because you're in the fourth category, and there's only a certain number of visas available for each category. Okay, so immediate relative visas are not subject to any type of numerical limit, right? So if you have an immediate relative, and we'll discuss who is considered an immediate relative, if you have an immediate relative, that you don't have to wait. You can apply for your visa instantly, immediately, and that's kind of what that means, immediate relative visas. Okay, so that is really beneficial. Because if you have an immediate relative, you can, tomorrow just start an application for them. Okay, so who is considered an immediate relative? An immediate relative for U.S. immigration purposes is the spouse of a U.S. citizen, the child of a U.S. citizen, or the parent of a U.S. citizen. So if you notice, these are all U.S. citizens that the family member is related to, right? The spouse, child, parent of a U.S. citizen. So those are the only three family members that would fall under the immediate relative visa type. Okay, so let's focus on the parent because that's what this webinar is about today. So who's eligible for this visa? Okay, first, the U.S. citizen must be at least 21 years old. The parent that the U.S. citizen is applying for must be a biological parent, a step parent, or an adoptive parent, right? Biological is easy. Step parent, adoptive parent come with, some additional requirements, which we won't discuss today for the sake of time. And as I mentioned, permanent residents cannot directly sponsor parents. Must be U.S. citizen. Okay, so once you've determined you have an immediate relative, you want to move forward, how do you do it? So there's two paths you have to pick one of them to apply for your immediate relative's green card. So there's two, right? Adjustment of status, and I'll explain each one. So adjustment of status, the second one is consular processing. Consular processing is when your relative is physically located outside the U.S. So consular means, they have to go to their local consulate, go to, for an appointment, interview, go through the whole process at your relative's home country consulate. And this is obviously a very broad overview of the process, but consular processing, first step, you file the form I-130, and I'll explain that later as well. You file that form with the Immigration Service here in the U.S., and the U.S. citizen is filing that. The U.S. citizen is the petitioner for this process. And then in that form, you provide proof of your relationship, and I'll discuss that too in a little bit. So after that's approved, it gets sent to the National Visa Center. There's more documents you have to provide. And then it moves from the National Visa Center to the local consulate, and there's more information to fill out and provide, including, medical exam, financial documents, and things like that. Adjustment of status is the process where your relative is in the U.S. already. So consular processing, the relative is overseas. Adjustment of status is the relative is in the U.S., and the U.S. citizen is applying to adjust the status of whatever that relative is on to a green card status. I mean, that's basically what it means. So same, kind of similar process. First, the U.S. citizen is a petitioner still, files the Form I-130 with the U.S. Immigration Service, proves the relationship. What's different here is you can also file at the same time your Form I-485, which is the actual green card application. So the Form I-130 is proving the relationship. That's basically what it is. And so after you prove the relationship, typically you then, or it's approved, you prove the relationship, it's approved by the Immigration Service, and then you file your Form I-485, which is your green card application. But if you have an immediate relative in the U.S., you can file both of those at the same time. And then finally, now there used to be interviews, for parents, but that is very random now. Okay, so as I mentioned, each of those processes, every process, actually, a family-based immigration process requires the petitioner, who is a U.S. citizen, to file the Form I-130. And the purpose of this form is to prove the relationship between the petitioner and the applicant, who in this case is the parent. Okay, so as I mentioned, this is where you prove your relationship. This is where you also prove that you're a U.S. citizen. So you can provide your passport, you can provide your naturalization certificate. If you were born in the U.S., you can provide your birth certificate. And then, of course, you have to prove that your parent is your mother or father. So and it's different, the evidence that you provide for each. So for the mother, if you're petitioning for your mom, you must provide your birth certificate that shows the name of your mother. So of course it'll have your name because it's your birth certificate, but that birth certificate should name your mother. For your father, there's additional evidence required. So if you're petitioning for your father, again, you would provide your birth certificate showing the name of your mother and your father, so both. And additionally, you would have to provide their marriage certificate to showing that your father was married to your mother. So they do need additional data if you're applying for your father. They want to see that your mom and dad were married. They would want to see both your mom and dad's name on your birth certificate. So keep that in mind if you're applying for your father. Okay, so I know we covered a lot of different things, and as with any immigration process, there's so many forms, right? So, but the key ones are the Form I-130. So important because that proves the relationship. You can't move forward if the Immigration Service doesn't approve your Form I-130. The I-45 is what you can file it with the I-130 if you're located in the U.S. The DS-260 is for the consulate, for overseas consular processing applicants. The I-865, we haven't mentioned, I haven't mentioned it in detail because that's a whole webinar in itself. It's basically it's called the affidavit of support, and that's where the U.S. citizen has to provide the financial documents showing that they can financially support, in this case, their parent, but their relative, essentially. So there's a different chart that you have to look at to see how much money you need to make, what counts, what doesn't count. And that it's one of the factors in granting a green card to your relative is evidence of financial that you're able to support financially your relative. Okay, so summing it up, what's required for your parent's application, and if you're starting the process, you should start gathering your proof of citizenship. And again, if you're the U.S. citizen, it could be your birth certificate if you were born here. It can be U.S. passport, unexpired, and it could be, if you naturalized, your naturalization certificate. Your relationship documents, again, I went through that. How do you prove, what you need to prove the parent-child relationship? Identity documents is always required. So the Immigration Service wants proof of the identity of your relative. And finally, as I mentioned previously, the financial evidence that you can support your relative when they move to the US, or they're in the US and they get their green card. Okay. I raced through those slides. There's so much to cover. And now, though, I want to answer your questions about parent visa process. Okay. Yeah. So before I move forward, actually, I got a question. Several people, many people actually, were asking me about the recent AOS memo. I do want to address that because that's very important. AOS meaning the Adjustment of Status memo that came out, I don't know, I would say maybe last month, very recently, where the Immigration Service was saying that it's an exception to apply for adjustment of status in the US for certain visa holders, primarily like student visa holders or visitor visa holders. If you came into the US on some of those single intent visas, you have to leave the US if you want to apply for a green card. So that obviously raised a lot of concern and anxiety, because we've been applying for green cards for students, for visitors forever, and it was always gone smoothly, no issues. But now the Immigration Service issued that memo saying that if you're on one of these temporary visas, you have to return. So I've been getting a lot of follow-up questions about that. So the memo is actually still in effect. There was some miscommunication about whether it's still valid. It is valid. They have not pulled it back. So as far as we know, it's still valid. However, it's a matter of discretion to the immigration officer when they're reviewing your application. So I'll talk about what I know. What are the facts so far is that it's a matter of discretion, and a very limited number of cases have been denied in the US for adjustment of status. And that's the two cases I know about are there was a student who was applying for a green card, and they had some unauthorized employment. And then also there was a visitor on a B2 visa who applied, and there were some, other immigration violations in their history. So, I think right now, if you have a pretty clean immigration history, hopefully, it won't be an issue. But anyway, I wanted to provide that update because we've got a lot of questions about that memo. Okay, so here's a question about, do I need a minimum income? Yes, you absolutely do. So the way to figure out what income you need, the Immigration Service does have a chart. If you go to their website and you look up I-864P, which is for, their poverty level chart, something like that, it'll tell you how many dependents do you have. If you have if you have a spouse, 2 kids, they will, you follow the chart, and it will say how much money you need to show the Immigration Service, because you have to show that you can still support your dependents and this additional person. So that is the chart that they use. That's the chart we use to determine, what level of income is required to meet the financial support requirement. Another question that many people have asked is, can you travel if you if your parent has this process in place? Because it can take a long time, right? So if your parents in the US, they want to go back home, or if your parents overseas, they want to come visit you, can they do that? So if your parent is in the US and they file their application, they really should not, they shouldn't travel. They should not travel. They should not, I mean, outside of the US. And yeah, they shouldn't. It's just black and white like that. So if they leave without permission, they will be abandoning their adjustment of status process, right? And they'll have to pick it up overseas. So your parents and this comes up all the time, right? They, parents want to go home. And what you should do is wait. If they want to go home, wait until your parent receives their, it's called advance parole, which gives them temporary permission to travel. Wait for that, and then they can use that and go. And that keeps everything alive. It keeps the I-130 moving forward, the adjustment status process moving forward. If they leave before getting that, as I said, they will abandon the adjustment status part of it, and they'll have to go through a consular process. The other way around is if your parents overseas, they want to come to the US, they want to visit you, they want to visit your kids. No, unfortunately, because they have a immigrant process underway. So we're very conservative in this climate that we're in right now. I would not risk coming to the US if you have an immigrant process underway. And if you don't have a visitor visa, you'd have to go for an interview, things like that, and they'll know that you're trying to become a green card holder, and it usually doesn't go well. Okay. Any other questions? The other many questions many people have asked is, how long before I can apply for your parent to apply for their citizenship? So a parent has to wait 5 years, which is really the standard amount of time. So after it's the date you get the green card, it's 5 years from that date, and they can apply for their citizenship. But I mean, this is again a whole other webinar, because if they're traveling back and forth, the US outside, it could impact the when you can apply for your citizenship, because you have to have a certain amount of time in the US. Okay, so unfortunately I only have time, I think, for one more question. So regarding CSPA, yeah, that's extraordinarily complicated. CSPA is extremely complicated. So, what I recommend, I mean, no one should be giving a general answer to that, because you have to look at the actual profile. I would recommend you meet with a qualified family-based immigration attorney to help you see, how you qualify, yeah, it's a lot of math involved as well. So I unfortunately, I wouldn't be able to answer very generally here. Okay. I could turn to some of the questions as well that people submitted prior to the webinar. Oh, how long does the process take? Yeah. So it really depends. Like the consulate process it really is dependent on how long how long the wait times are for an appointment with your local consulate, right? So many, they're like really backlogged. So even if you have everything approved, everything, you're ready to go to that visa interview at your local consulate, you are subject to whatever appointment times are available, and it could be a very long time. If you're in the US, it is much faster to get your green card. And also, in the meantime, you also, if you apply for your I-45, you also get your work permit. I mean, if they want to work, usually they don't. Their work permit, their advanced parole, and so they can go back and forth. The times for processing, they vary. But the good news is, for several years now, they haven't been holding interviews for parents. So what I would do is, and what they will do is process your I-130 first, and then go to your I-45. Okay, that is all we have for today. It's all the time I have. I know there are a lot of questions about family visas in general, not just the parent sponsorship. So if you're interested, let us know. I would love to do another webinar on any of these other family-based visa sponsorship. So thank you so much for attending, and stay tuned for our next webinar.